Good morning to all of you. Welcome to CPC students, particularly the 5th semester students. Last year, that is 2023, there was a question in the CPC, maybe question number 17. The synopsis of the question is like this. A wanted or proposed to file a civil suit against the government, a government officer, that is public officer. So, as a mandate which is mentioned under section 80 of the CPC, he has given a notice to the concerned department. You know, as per section 80, no case should be instituted within 2 months. He has to wait for 2 months. He waited, but to the misfortune, he died. He is no more. But the right to sue is surviving. Therefore, his legal representative wanted to pursue the matter. Now, for instituting the civil suit, previous notice given by the deceased person is sufficient or not? This is the question. A has given notice of proposed suit under section 80 CPC, but A dies before the institution of the suit. A's legal representative wants to file the suit. Is notice given by A sufficient or not? Same question. Decide. So, it's a very simple question, simply relating to 80 of the CPC as well as order 22 of the CPC. You have to mention both. Basically, before answering any question in part C, you have to remember that you have to write the brief facts of the case. What are the brief facts? That means the question should be divided into 3 or 4 simple sentences. Like A has given a notice. The notice, because he is a public officer, it's given under section 80 CPC. He has to institute the suit after 2 months, but he died. But the right to sue survives. His legal representative, maybe his son, wanted to continue the suit, wanted to institute the suit. Is it sufficient or not? So please remember, when a party issued a notice to the government servant, and when the question arises, when he dies, whether the same notice is sufficient or not, 100% sufficient, because Supreme Court has clearly stated that it is only a procedural matter. It is only to give the government a time frame to settle the issue, because government servants, they don't do things, they don't commit the so-called civil offenses for their personal ends. And once it's a government issue, definitely you have to wait for 2 months. It is only a procedural aspect. Right. Now, requirement of notice is only procedural in nature. The object is to give the government an opportunity to consider the claim before the litigation is initiated. Please remember, substantial question with the notice is important. Yes, whether notice is given or not, yes, it is given. So, LRs always they can continue the case. This is what is stated in the very famous case of State of Punjab versus Mst.Qaiser Jehan Begum, 1963. Friends, I told you the case law in relation to another thing. So, delay, condemnation of delay. Qaiser Jehan Begum was a widow. Her husband was fighting with the state government regarding the compensation in a land acquisition case. He used to attend the court. This because she is a Pardashin lady, she never went out of the house. But he died. He died. And after 6 months only, she came to know that the pending case has to be continued. But to go for the appeal, the limitation period is over. So when she filed the case, Supreme Court stated that the limitation period starts from the date on which it comes to the notice of the plaintiff, notice of the petitioner. In that connection I told you, but here also she can initiate the suit as LR when the cause of action is there, when the right to sue is there. Very good case law. You can cite it in this also. Second case law, Ghanshyam Das and others versus Dominion of India, 1984. In this case also, Honorable Supreme Court of India held that the purpose of notice given under Section 80 CPC is to give an opportunity to the public officer to settle the claim. When once the notice is given, subsequent death of the party or subsequent death of the person who issued the notice does not render it invalid. Yes, LRs can continue. Coming to Order 22, you have to know this also. Order 22 deals with death, insolvency or marriage of the parties, if I am correct. 22 కదా ఒకసారి చూద్దాం. Death, marriage and insolvency of the parties. Rule number 1, no abatement by the party's death if the right to sue survives. The death of a plaintiff or defendant shall not cause the suit to abate if the right to sue survives. So definitely the legal heirs can continue. Here the point is, the suit is not instituted. If the suit is instituted, all these things you can generally understand. But even then, if the notice is given, then that itself is sufficient. So please remember, this order is applicable, please remember, and as a right in rem. That means everybody can utilize it if he is properly having the position as a legal representative. So, very good question. Seems to be very, very simple. Normally, we focus only on 80 CPC. At the same time, Order 22, Rule 1 also you have to mention. Right? With this, I am concluding. Thank you very much.